A very good evening to all of you. In the last class, we have completed the concept of will. In this today's class, we will understand the concept of trust, Indian Trust Act, how the trust deed we form. Everything we will learn in this today's class. But first of all, let me share a screen with all of you. Yes. For an example, so what is trust and how we make a trust deed? Let me tell you this bit. For example, this is Mr. Pratik. No problem, sir. Pratik has, let's say, 10 crore rupees plus 20 crore rupees immovable properties, let's say. No problem. I have a problem. The problem is what will happen after my death. That is the most important point. For example, if I die, all this property someone may misuse. That is why I want to appoint one person, let's say Mr. Piyush, who will use this property. And yes, whatsoever I give the instruction to Mr. Pratik, to Mr. Piyush, this property will be utilized to accomplish my instruction. For example, I said, Mr. Piyush, you will take care of my, let's say, children out of this property when I die. What do you think? Whether this is a concept of trust? Yes or no? Please give me the answer in the chat box. If I say to Mr. Piyush, Piyush, I have this property, let's say 10 crore rupees bank balance and 20 crore rupees immovable property. And I am saying, Mr. Piyush, take all this property. After my death, you will utilize or you will give the property benefits to my, let's say, wife and as well as my son and daughter. Is this a concept of will? Not the will, the trust. The answer is yes or no. I cannot see any answer. Aditya is saying yes, Pritika is saying yes. The answer is yes. So it means the trust is very simple. I have a trust on some person, let's say Mr. Piyush. Mr. Piyush will use this property to accomplish one objective. This objective may differ. For example, I can say, Mr. Piyush, please give the benefit of this property to, let's say, my family. So this is a private trust. If I say, Mr. Piyush, take this property to you, and yes, use this property for the charitable purpose, for the general public. This is again a trust, but this is a kind of public trust. Understood? So the trust is very simple. I will transfer my property to some another person. The name of such another person is trustee. I will transfer my property to some another person, and some another person will use the property for the benefit of, let's say, some private person or some public persons. Now, let me first of all share a screen. So this is Mr. Pratik, this is Piyush, and let's say this is a general public. For an example, so this Mr. Pratik is a settler. What is this? This is a settler. Mr. Piyush is a trustee. And this general public is the beneficiary. This general public is the beneficiary. Understood this point as of now? That in the case of trust, doesn't matter if your trust is a public or if it is a private, doesn't matter. There will be the three parties in the trust. One is the settler. Settler means Pratik. I have trust on some another person. One is trustee, that is Mr. Piyush. The third person is beneficiary. How this property will be allocated to another person, or let's say to my family members. So this is an example of trust. So sir, I have a question. How this type of transaction can be held? Whether this can be held orally. Sir, I call to Mr. Piyush. Hey Piyush, I have a trust on you. Please use this property after my death for the benefit of my wife as well as my children. Whether this is an example of trust, yes or no? Anyone? Please do let me know the answer, whether this is the example of trust. Archana, Aditya, Pritika. No one. One day I called to Miss Archana. Archana, I have trust on you. Please use this property after my death for my children's. Whether this statement will create the trust, yes or no? The answer is we have to check. We have to check, Archana, as well as Acha. What? I don't think so. Okay, very nice, Pritika. We have to check if we are creating a trust on movable property. If we are creating a trust on movable property, the registration of trust is not required. First thing. Second thing, if we are creating a trust on immovable property, land, building, etc., then registration of trust is required. It means the preparation of trust deed is not mandatory when I am transferring the movable properties. But yes, the registration of trust is mandatory when I transfer the immovable property. So I have a question. For an example, Mr. Pratik is transferring movable as well as immovable property to Mr. Piyush, who is the trustee. No problem. Whether it is mandatory for ourselves to get this trust registered. Is it mandatory? What do you think? I am transferring both movable as well as immovable property. Whether the registration of trust deed is mandatory in this case. Yes or no, beta? Yes, Chinmay is saying yes, Sudhanshu is saying yes, Aditya, Mansi, everyone is saying yes. Because beta, I am transferring both movable as well as immovable property. Whenever I transfer the immovable property, registration of trust is required. Got the point? Yes, sir. So one thing is clear, that when the registration of trust is required, the second thing is how many parties are there in the trust. One is settler, one is trustee, the third one is beneficiary. This beneficiary can be a general public, or this beneficiary can be a private person. Okay. Private persons means, for example, my wife, my father, my sons. No problem, sir. Understood. When the beneficiary is general public, this type of trust is known as public trust. Okay, sir. When the beneficiary is private persons, means my wife, my father, my son, etc., 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 this is known as private trust. Understood, sir. But yes, the most important thing is whenever you transfer the immovable property, the registration of trust is very, very much required. Understood this point as of now. So there is an act that is known as Indian Trust Act 1882. Trust Act 1882. And we are learning the provisions of Indian Trust Act 1882. Understood. First of all, also let me share this example with you. So we have understood this Indian Trust Act. There is an act that is known as Indian Trust Act 1882. This one. Furthermore, we have understood this thing that there are three persons in the Indian Trust Act. One is settler, one is beneficiary, and one is trustees. Sir, I have a question. This is the most important example for you. Sir, I am saying, Piyush, I have some properties with me. Let's say movable property and some immovable property. I called to Mr. Piyush and said, Piyush, I have trust on you. Please, I am giving you the possession of this property. Kindly use this property for the benefit of Mr. Pratik. Whether this is an example of trust, yes or no? Do let me know the answer again in the chat box. Whether this is an example of trust. The answer is yes, Pritika, Archana. Archana is saying yes. Everyone is saying yes. Okay, Archana, why? Pritika, why this is a trust? Please do let me know. Please do let me know why this is a trust. You're very much allowed to unmute. Chinmay, you are very much allowed to unmute if you want to give me the answer. Yes. Anyone? Sir, for example, if I am saying, Mr. Piyush, I have trust on you. Use this property for the benefit of me. Whether this is an example of trust. As per your opinion, you are saying, yes, sir, this is an example of trust. But let me show pair act with everyone. Just a second. Yes, Pritika, whether this is an example of trust, beta?
No, sir, no.
Why? You said yes.
Yes, yes.
Sir,
I
more
think
like a
a
power for him.
trust has to be made for the benefit of other person. One cannot make a trust for himself.
Okay. So you are saying, sir, you cannot make yourself beneficiary. Yes.
Yes.
Achha, let's
And
say
if
for
you're authorizing, like trusting someone and it's for your benefit, then it looks more like a power of attorney than a trust deed.
very nice, Archana. Shabash. See, this is not the example of trust. But let me give you third example. For example, I called Mr. Piyush and said, Piyush, I have trust on you. Please use this property for the benefit of me as well as my wife and son. Whether this is the example of trust now. Yes. Anyone?
Yes, sir.
Yes. Archana is saying, yes, sir, this is the example of trust. But again, I am the beneficiary in this case, Archana, yes or no?
Acha, sorry. I thought the beneficiary is wife and son.
No, I said, Piyush, use this property for the benefit of me as well as my son and wife. Yes. Whether this is a trust. The answer is Pritika. Pritika is saying no. But
So,
the answer is, let me
so
show you.
won't it be valid partially?
Yes, beta?
So, like, partially it will be valid because, like, it's
Asha, you are saying, sir, the person who is the settler cannot be a beneficiary. That is you want to say? Yes, beta, that you want to say?
no, sir. Sir, I'm saying like you gave the example that A is entrusting B with his property, saying that it's for my benefit, like A's benefit, and for the benefit of his wife and children. So the part where he says it's for the benefit of him, can't that be severable? Like, can't that be severed, and only the part where the like it's for the benefit of his wife and child that will be valid?
Okay, so you are saying, sir, for example, if I called to Mr. Piyush and said, Piyush, use this property for the benefit of me as well as my wife and son. So, sir, the trust which is created in your favor will be invalid. Second thing, the trust created in your wife favor is okay. Yes or no? You want to say this?
Yes, sir. Yes, sir.
Okay. Yes, anyone? What would you want to say, Archana and Pritika, anyone? Yes.
No, sir, I'm confused.
Confused. That's my purpose to confuse. यही तो purpose है. Let me show you the pair to make you understand in the easy language. Just a second. So the question is whether the trust others, where it is. Just a second. After you are here and you are practicing advocate, I guess, what you would like to answer, whether this is a case of trust. No idea, sir. Sudhanshu, beta batao. Just a second. Settle up. No answers. Just let me go through with this bare act. The answer is, if I create a trust, for example, if I call to Mr. Pratik, Mr. Piyush, and say, Piyush, use this property for the benefit of me as well as my wife. This is okay. This is absolutely fine. But if I say to Mr. Piyush, Piyush, use this property for the benefit of me only, this is not valid. This is zero. This is not a case of trust. Just a second, better. Let me just show you one bare act. Beneficiary, yes. So as per, you can say Indian Trust Act 1882, there may be two cases. One is, Aditya, you want to say something about that? No, sir, confused. Everyone is saying confused, sir. Doctrine of severability. The answer is no. For an example, Veda, as per Indian Trust Act, if you create a trust and the beneficiary is only you, this trust is not invalid. This trust is not valid. This is not a case of trust. If the only beneficiary is trustee, or you can say settler. But for an example, if I call to Mr. Piyush and said, Piyush, use this property for the benefit of me as well as my wife, this is okay, no problem as such in this case. Furthermore, I can also say, Mr. Piyush, use this property for the benefit of my wife only. This thing can also be happened. So there are three cases, but the thing is that settler can not only be a beneficiary. Settler can not only be a beneficiary, but yes, apart from settler, some another person may be a beneficiary. All right, let me show you one example. If I open a charitable trust, let's say ambulance, no, not the ambulance, let's say dog welfare trust. Don't you think I will also, you can say, I will also take care of my dog in that trust also. So yes, only note, the problem is if only the settler is the beneficiary, that's the problem. But apart from the settler, if some another person are also beneficiary, that is not a problem as per the Indian Trust Act 1882. Understood? Yes or no? Any doubt to anyone? Archana, Pritika, Chinmay, Aditya, anyone? Yes, Archana?
No, sir, understood.
No, sir, clear.
Okay. Again, let's move further. Yeah, this is, what is this? Yes, civil code. Yes, let me show you this, not the will. Yes, this is important. Just a second. How many of you are interested in RERA practice? I just want to confirm. No one. Pritika, are you interested in RERA practice? See this beta. Now, most important example now. This is. So in the trust, there will be a preamble. Understood. The brief history about the property, etc., etc. Trust name will be there in the trust deed. Place where its office shall be situated. So I have a question. Sir. For an example, if I want to create a trust, let's say Pratik Charitable Trust for an example, how this trust will be created first of all. So first of all, if you want to create a trust, if you want to get this trust registered. You have to draft a trust deed, first thing. Thereafter, beta, you will deposit this trust deed with where? Anyone? How to register the trust? No one. Yes, Pritika, any opinion? How
Is
to
it
register the
registrar
trust?
of trust?
Registrar of trust.
I'm just making guess.
Okay. Yes, Sudhanshu, Archana, anyone? No one, sir. Registrar of trust. Okay.
Trust registry, I don't.
Yes, beta.
The trust registry.
Trust registry. There is no trust registry. There is no
No
trust.
idea, sir.
Yes.
No, I don't know.
No idea, sir. So how registrar of trust Archana is saying? Okay. But the answer is no. I will let you know within a 5 minutes. Do not worry. But let me first of all share a trust deed with you. This is most important. So here it is. Let me show you this. This deed of trust executed at, let's say, with New Delhi. What is this? Yes, New Delhi, let's say. On, let's say, you just have to mention the date. There will be the person is settler. Sir, I have a question. Why we are not including the legal heirs of the settler? Because I am not writing that the settler includes his legal heirs, legal representative also. Why I am not writing this? Anyone? Pritika, Archana? They are the beneficiary. Very nice, Chinmay. They are the beneficiary. Very nice. But the thing is that we never mention the legal heirs, the beneficiary, the legal representative in the case of settler. In the case of settler, never mention this. I have seen one trust deed also wherein the person mentioned, unfortunately, the legal heirs. The answer is no, we will not include this persons in this case. Furthermore, this. So who are this person? These persons are the trustee. Let's say I will write the name of Mr. Piyush here. And yes, so for example, if Mr. Piyush dies, don't you think that there, or you can say his legal representative will execute this trust deed? Yes or no? If Mr. Piyush dies, his legal representative will execute this trust deed? Yes or no? The answer is yes.
Yes.
Well, that is why in the case of trustee, we will include this person's survivors, legal representative, etc., and etc. But we will not include all these legal representative in this settler person. Understood, sir. Thereafter, Veda, what I am writing, whereas the settler is possessed with, let's say, 2 crore rupees, and I have some immovable properties also. And you know very well, if I have some movable as well as immovable property, whether the registration of this trust is mandatory, yes or no? The answer
Yes.
is yes.
Yes.
That is why, beta, I am preparing a trust deed. Okay, sir. No problem. Yes. Yes, Mansi, you are allowed to unmute. Please go ahead.
So, in private trust, if there is a general trust, public trust, not that every time the beneficiaries will be the family, then why in that case we don't take as party after settlers, like for their heirs and legal representatives?
Okay. So, for example, Mansi, you are saying, yes, sir. For example, if I am preparing a private trust, yes, and the beneficiaries are, let's say, my wife and my son. Okay. So I am the settler. I am the settler. I am saying my dad, I am saying to my dad, Dad, please use this property after my death for the benefit of my son and my wife. I will not include my legal representative in the settler definition because I am at present signing this. Who will execute? Who will execute this after my death? Trustees. So I will include the legal representative of the trustees. For example, let's say Piyush dies. Who will execute my trust? Yes, Mansi.
They're legal, yes. But sir,
They-
what if it's a public trust?
Yes.
Then
Again, in the case of public trust also, beta, you will include the name of trustees. Yes or no?
yes, sir.
Whether your trust is public or private, you will have to name the name of trustees who will execute this trust deed. And for example, if trustee dies, who will execute this trust? No one. That is why we include the legal representative of the trustees. You got the point? Yes, Mansi?
Yes, sir. Yes.
No, not yet, I guess.
But sir, what if the settler dies?
If the settler dies, no problem. If the
We
settler,
can't
yes,
we can't add any other party as the first party in addition to settler for
No.
like his legal representatives.
no. If the
Okay.
settler dies, nothing. This trust will continue in the future. You got the point?
Okay. Okay, sir.
The trustee will execute this trust, and the beneficiary will be as mentioned in the trust deed. You got the point, Mansi?
Yes, sir.
Any other doubt to anyone? Two participants, let me say. Ashna, yes, go ahead, Vida.
Sir, who can be a settler and a trustee? Matlab anybody. It can be organizations also.
It can be organizations also. For example, sir, you are saying who can be a trustee? Yes.
And settler also. Matlab.
And settler. Sir, for example, if my son, let's say he is 8 years of age, whether he can make a trust, do let me know, Ashna, whether he can make a trust. What do you think?
No, he cannot make a trust. Minor.
Minor. So it means better a trust can be created by a person who is competent to contract. Yes or no?
Okay, huh. But so it can be between two organizations also.
Oh yes, organization can also hold a property, or you can say organization are competent to contract. So
Matlab any legal entity who is
Ye-
competent to contract.
yes, for an example, sir, Reliance Industries can also create a trust. Yes or no?
Yes.
And so I have another question: whether Reliance Industries can also become, let's say, a trustee. Please do let me know whether a Reliance Industries can also become a trustee. Yes or no? The answer is yes. No problem as such.
Yes.
Any person who is capable to contract can be a trustee as well as the settler. Yes. Any doubt?
And beneficiary can be anyone, irrespective of being minor or major or anything.
Oh, very nice question. Very nice question, Ashna. So I have another doubt. Who can be a beneficiary? Who can be a beneficiary? Any other doubt to anyone? The answer is yes. Ashna, do you want to answer? Who can
Sir, I
be
think beneficiary can be anybody.
anybody?
Okay.
Anybody means 2-year child, etc., etc., etc.
Yes, I
Yes.
think so. Yes.
Yes, because he will not have any liability attached to him. So beneficiary can be of any age.
Okay, very nice. Beneficiary can be
Even
any
in
person.
contract, we usually contract, maybe this is followed now that for the benefit of minor, we can.
Create a trust. Or you
Yeah.
can say a benefit can also be given to the minors.
Yes.
There's no problem. Beneficiary can be any person. But the thing is that trustee as well as settler cannot be a minor. Yes, Ashna,
Okay, sir,
any
yes.
doubt to anyone now?
No.
Sure.
Yes.
Yes. So, sir, understood who can be a trustee. How this is okay. Understood this point. as of now. Now, let's move further. Just a second. Here it is. Here it is. So who can create a trust? Understood. How this trust will be created, I will let you know within 5 minutes. But first of all, let me share a screen with all of you. Yes, anybody. Very nice. This one. This one. Yes. Furthermore, beta, this is okay. The first thing is settlement. This is important point. The parties of the first part, it means the settler, hereby settle the sum of rupees, let's say 2 crore rupees, interest with the name and objects that will be mentioned below by delivering the said amount whatsoever to whom this amount will be delivered to the trustee. This amount will be delivered to the trustee. Furthermore, the name of the trust you have to mention, where the place of the office will be, you have to mention, what will be the objects of the trust, you have to mention, this educational, medicine, etc., 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 that you have to mention in the trust. So it means, beta, this is a general trust, a public trust, because I will give the benefit of this property to every person who is old age, etc., etc., etc. This is again important. Beneficiary, benefit of citizen of India. It means, so this is a public trust. Public trust. So I have a doubt. Let me ask you one thing. For an example, if I am creating a trust for the benefit of old age person, whether this old age trust can amalgamate means can join the hands with educational trust, yes or no? The answer is no. We cannot. We have to check what our objectives are. We can make a friendship with some another person whose ideas are same. Just like this, beta, we can amalgamate only with those NGO who have same object as per our trust. That is important again. This is the trust, this is the fund, this is the investment. This is the most important point now. Let's say, beta, sir, I have another question. Sir, settler will be one person. Whether there can be a 5 trustee in this trust deed, yes or no? The answer
Yes.
is yes. Trustee can be any number, no problem as such. But sir, I have another doubt. Whether a settler can also be a trustee, yes or no? This is the most important part. Whether a settler can also be a trustee as per Indian Trust Act 1882. Anyone? Yes, Archana, Pritika, Chinmay. What do you think? Whether a settler can also be a trustee, yes or no? Yes, Archana? No, sir. Everyone is saying no, don't know, don't know, don't know, don't know. But the answer is, अरे sir, जब तक मैं जिंदा हूं, तब तक तो I can take care of my property also to some extent, yes or no? Try to think like this. As of now, I am transferring the property to Mr. Piyush. But for example, I am still living. I am still alive. Don't you think that a settler can also be a trustee as long as he is alive? Yes or no? What do you
Yes,
think?
sir.
Otherwise, तो वो मेरी property बेच खाएगा, मैं क्या करूँगा? Yes. So let me show you one another proviso.
Sir,
Just
I
a
got a
second.
doubt.
Yes, please go ahead.
Sir, just now you said that settler can be trustee, but if a settler dies, then will that not be contradictory to that clause of adding assignees legal heirs?
Okay, so I will write in the trust deed that, for example, this person will be a trustee as long as he is alive.
Okay.
Furthermore, I will also include that this person trustee will not include the legal heirs. You
Okay.
got the point?
Okay. Okay. We can give clarity on that point.
Correct. We should give the clarity in that.
Okay.
Understood, sir.
So, sir, in that itself, we can add, no, like after the death of this particular person, this person can act as a trustee and all of that.
Correct.
So
can
we
add
can,
this.
okay.
See this. The first managing trustee shall be the settler. सोचो why I am writing this? अरे sir, otherwise तो दूसरा इंसान मेरी property बेच खाएगा. So as long as I am alive, I will write this, that this first managing trustee shall be the settler and he will hold office for his lifetime. Yes or no? Understood this point? Yes, sir. After the demise of the managing trustee, understood, the remaining trustee, it means, let's say Piyush, shall elect one of the other trustee as the managing trustee. So we will not include his legal heir. Yes or no? You got the point, everyone? This is the clarity. So the term of office of first trustee shall be their respective lives. That is the most important point for everyone. I hope this point is clear to everyone, that a settler can also be a trustee as long as he is alive. Otherwise, some other person will sold all my property and he will go to the, let's say, some other place just like Vijay Mallya. So to protect my interest, my wife interest, my kid interest, I will include my name also in the trustee. Yes or no, beta? Understood. Now, sir, this is a very general concept, administration, etc., etc. But let me show you this. There is a section, and the name of section is, as far as I remember, 12A of Indian Trust Act. Oh no, not the Indian Trust Act, Income Tax Act. 1961, there is a section that is named as section 12A of Income Tax Act 1961. Anyone have the idea with respect to this section? The answer is yes, Pritika. Do you know this section 12A of the Income Tax Act? No idea, sir. No, sir. Ashna, not at all. Shaitan.
Sir,
Okay.
income included in total income?
Sorry. Yes, please go ahead.
So section 12 talks about incomes that are not included in total income for computation of taxes, tax liability.
Section 12A. Is it
Section
so?
12.
No, I am saying section 12A. Let me show you this bare act. Just a second, bro. Just a second. Okay, this is Indian Trust. This is Income Tax Act, section 12A. Most important section, practically being used by various persons. Section 12A, most important example. Let me show you the bare act of this section 12A. See this beta. Just a second. Here it is. So this is income of trust. This is income of trust. Do you know one thing? As per section 12A of the Income Tax Act, my trust will, you can say my trust will gain some income. But this just is for the general public welfare. Let's say for an example, don't you think some relaxation should be given to me? Arey sir, whatsoever, I am using my property for the benefit of poor peoples, and you are imposing tax on me, 30% tax. Don't you think this is unfair? Answer yes. That is why this section 12A is very useful for everyone. Yes. The Income Tax Act 1961 provides exemptions to the trust, and you have to obtain license under section 12A of the Income Tax Act 1961 to avail that exemption. That is why you must have heard from your chartered accountant friends, and they must have informed you, yes sir, I want a certificate under Section 12A of the Income Tax Act 1961. This Section 12A certificate is nothing. It is just like your income will not be taxable for some period if you comply with some conditions. Okay, so whenever we register a trust, we also should obtain a license under Section 12A of the Income Tax Act 1961. Yes or no, beta? That is why we will write this in the trust deed also. That, sir, let me again share a screen with all of you. Here it is. Yes, to invest the trust fund in the manner not prohibited by the provisions of Income Tax Act 1961. For an example, so this is Pratik. This is Piyush. If I am transferring the property to Mr. Piyush, I have a question for everyone. Whether this property, let's say 10 crore rupees, whether this property can be invested in the stock exchange by Mr. Piyush? The answer is yes or no?
No, sir.
No. Archana is saying no. Pritika is saying no. Okay, everyone is saying no. But why no, beta? Why no? If the property is idle, ऐसी पड़ी हुई है, no use, why cannot we invest this property somewhere? Yes or no, beta? And whatsoever we will have income from this property, this will also be a part of this trust. So I can invest the property of the trust to some another funds. For an example, I can invest the property in real estate, etc., etc., etc. But whatsoever the income I will have, this income will again be the part of trust deed. So where it is written, let me show you this. The property, where it is the property? Yes, say this better. The amount transferred, okay. All addition, accretion to the trust property and the income therefrom. This is most important. It means, beta, I can invest, the trustee can invest the idle property to some another place. And yes, whatsoever the income we will get from that property, this will again be added to the fund of this trust. Yes or no, beta? Archana, any doubt to anyone now in this point? No, sir. Yes, Pritika, Chinmay, any doubt to anyone?
No, sir.
Very nice. This managing is okay. Thereafter, this is a very general points. Bank account, audit bhi hogi, sir.
Sir, I have one doubt.
Yes.
So, matlab, if the trustee says that, he wants to mortgage that property and take loan, and that loan amount will be used for the beneficiary purpose, is that okay?
Okay, you are saying, sir, this trust wants to obtain a loan for the benefit of
The
trustee,
beneficiary.
for the benefit of beneficiary, right? Okay, that's why the property is being mortgaged to some another person. The answer is yes, this can be done.
Okay.
Done. This can be done. Any doubt to anyone now? So what is this? This trust is declared irrevocable. What is this, sir? It means, beta, there are two types of trust. One is revocable. One is irrevocable. Understood, sir? So what is this revocable? For example, I cannot take my words back in the case of irrevocable trust. But yes, I can take my words back. I can take my property from Mr. Piyush in the case of revocable trust. So when I can end up this trust, this is known as revocable. When I cannot end this trust is known as irrevocable. Ria, how are you, Ria? I will ask some questions from you. Thank you. Okay. Furthermore, beta, this is okay. Amalgamation, I have informed you this, that we will only dosti karenge, we will only amalgamate with some another trust who will have the same object. I cannot amalgamate with educational trust if I am running a old person trust. That is again important. Okay,
Sir.
sir. Yes, sir. Yes.
Sir, in case of trust, is there something like you said that there is revocable and irrevocable? So in case of revocable, like can it be done unilaterally? Like the settler says that I'm just canceling the trust deed, but the trustee doesn't like accept the fact. So is it like the consent of both parties is required, like in case of gift or not?
Arey sir, I am transferring my properties to you. This is my property. I cannot take my property back. Don't you think? Yes, in me.
Yes, sir. Yes, sir.
Yes. So if the trust is revocable, trustee can revoke. Okay.
Okay, sir.
Any doubts in me?
No,
Very
sir.
nice. I am so proud that students are asking me questions. ऐसी तो मजा आएगा पढ़ने का. Very nice. Thereafter, sir, this is the dissolution when this trust can be dissolved. Dissolve means beta bye bye. Bye bye means wind up. For an example, beta, this is a very simple examples. In the event of dissolution or winding up, all these assets will be transferred, etc., etc., etc. This is important. Thereafter, beta, I will write the properties which I am transferring. This assets, this property, this cash, etc., etc., and etc. And again, beta, we need this settler, this witness, and this trustee sign. So I have questioned whether the signature of beneficiary is also required to make a trust. The answer is yes or no.
No, sir.
No. The signature of trustee, the signature of settler, and the signature of witness are required. The signature of beneficiaries is not required. You got
Sir,
the- Yes.
no doubt. So if at all the trustee is not doing his part properly, so will the beneficiary have any rights, or can he take any action? Like what recourse is available if the trustee doesn't fulfill his part in executing the duties?
Okay. The trustee hold the fiduciary relationship, the first thing. So what is this fiduciary relationship? Anyone? Ashna, what is the meaning of fiduciary relationship? It
So
means
relationship of trust.
relationship of trust. Very nice, Pritika. Everyone, correct. So for example, if beneficiaries are saying that this trustee is not acting as per the objective of this trust, action can be taken against the trustee. In one of our case, just I guess 2 years back, we have initiated a case against trustee. Whatsoever the profit arise to that trustee, we have recovered all this profit, and we utilize all this profit for the benefit of beneficiary. Got the point, Ashna?
So, but matlab the settler took action against trustee.
Beneficiary can also take the actions.
Beneficiary can also take the action. No, okay.
Correct. You must have read Indian Contract Act, and section is section which one? Section 25, I guess. No, where there may be a stranger to the contract. See, the contract is between, let me show you this. This contract is between settler and this is trustee. Don't you think that the beneficiary are stranger? Yes or no? Please do let me know whether beneficiaries are party to this contract. Yes or no? The answer is no. But again, very nice, Pritika, so proud of you. Beneficiary can initiate a case as per the Indian Trust Act, because privity of contract is an for example, trust is the exemption of privity to the contract. याद आया किसी को? Yes, Ashna, remember?
Yes.
So
So
all
if
these
the
concepts
settler
are
is,
interrelated.
so even if the settler is alive, to be the beneficiary has right to take action again.
I said, for example, let's say I am the father. I am saying, daughter, you will marry this person. So my daughter, as well as me, can initiate a case if the person took 1 crore rupees from me and he not married. Yes or no? So my daughter, as well as me, can also initiate a case. Yes or no? Yes. Yes, that is the examples of Indian Contract Act. Yes, sir. Any doubt to anyone now in this case? No, sir. So
No.
understood, sir. Beneficiary is not signing. Still, a beneficiary can initiate a case because he is the beneficiary, and as per the Indian Contract Act, a beneficiary can also initiate a case because privity of the contract does not apply to the trust. So we have completed the concept of trust. Again, this is an example of private trust. I'm again sharing this sheet with you. You may read, you have 5 or 6 days with you. Do let me know whether I have shared the will document with you as of now. The answer is, I guess, no. So I'm just sharing the will document that we have learned in the yesterday class. Furthermore, this private trust concept and the public trust concept, this documents with everyone in the WhatsApp group. But still, if you have doubts, you are very much allowed to ask. Pritika, Chinmay, Riya, Adarsh, may I know the name of this person? No. Mansi, any doubt to you? Mansi, you raised your hand. Please go ahead.
So, what is the difference? I mean, is it the terminology only that we are creating a trust, will, or power of attorney?
Okay, you are saying, sir, what is the difference between trust and the power of attorney?
Yes, sir. And will.
Okay. Anyone would like to answer what is the difference between power of attorney and trust? No one. Ashna?
Sir, power of
Yes.
attorney, I think you authorize a person to act on your behalf.
Okay. It means I am not transferring the property to some another person. Yes or no?
Yes.
And in the case of trust, I am transferring the property.
Yes, yes.
That is the very, very important point. Ashna, kya
But
padh rahe
then-
ho beta aajkal? Yes.
Because in power of attorney, you basically just give them the right to act on your behalf. You don't transfer anything to anybody.
Correct. You got the point, Mansi? No.
Yes, sir. Yes.
That's the difference. Anyone would like to add on? Pritika. What is the name of this person? Archana, Rahel. Very nice, Rahel. After Aditya, how are you? Would you like to answer this? What is the difference between power of attorney? The answer is very nice. Archana has given the very beautiful answer that in the case of power of attorney, I am not transferring the ownership, or you can say I'm not transferring the properties. But in the case of, let's say, this will, not a will, trust, I am giving the property to some other person, and this will benefit all the general public or my wife, let's say private persons. I had a doubt, Mansi? Rahel, okay, very nice. Very nice, Rahel. Rahel is saying no beneficiary required in power of attorney. Very nice. I will not mention the name of this is this person, but yes, I will write the name of my daughter, my son, as well as my wife if the trust is private trust. Yes, Mansi, any other doubt, beta?
Yes, sir.
Yes, any other doubt? Please, pucho. Please go
No,
ahead.
no, no, sir. Thank you, sir. I said.
Okay, okay.
Sir,
Yes.
sir, right now, like you specified that in case of power of attorney, the property is not transferred, but in case of trust, the property is transferred. Sir, right, like Abhi, we studied that even in a trust deed, the settler can be made a trustee. So
Correct.
in that case, like, is there like does the transfer of property means transfer of ownership of the property? Because if we are
Okay.
saying that in the trust that the settler is also one of the trustees, and like in that
So,
case there is
so
no.
for example, I will keep some property with me. Got the point?
Yes, yes, sir.
So let me show you this. A board of trustee will create. Board of trustee mean, for example, Pratik, Piyush, and let's say Pratik father. So this will be termed as board of trustee. I will transfer all my property to the board of trustees. Got the point? After my death, the two person will manage this property. Yes.
Yes,
Got
sir.
the
Yes,
point?
yes, sir.
Any other doubt in me?
Sir, also, yes, sir. In case of, like we discussed, Abhi, about private trust. So, in case of public trust, then the beneficiary is public. So, in that case, then it means that public can file a case in case of any misuse by the trustee, right? Like a
Correct.
public interest litigation or something.
Yes.
Okay, sir.
No, the public interest litigation, writ can be happen, civil suit can be initiated, all these things can be initiated.
Okay, sir. Okay.
Okay. Any other doubt?
No, sir. Thank you.
No. All right. Any other doubt to anyone so that we can wind up the class? And I will sharing this all these documents with you in the WhatsApp group. No, sir. Okay. Thank you so much to everyone. Please take care. Stay safe. Keep learning. Keep enjoying. Thank you.
Thank you, sir.